Hello, my name is Donna and I'm a Solicitor and Community Liaison Officer with the Welfare Rights Centre. Today I'd like to have a talk to you about Centrelink and how domestic and family violence can affect people's payments and relationships with Centrelink. I'd like to start by acknowledging that I am talking to you from the land of the Gadigal people of the Eora Nation. I'd like to acknowledge Aboriginal leaders past, present and emerging, and any Aboriginal people that are watching today. I'd also like to recognise that the land that I am on was never ceded, that it always was and always will be Aboriginal land. So I want to start by letting you know who we are as the Welfare Rights Centre and what we do. We are a community legal centre. We specialise in social security law. So the entirety of what we do is assist people with their payments from Centrelink and their relationship with Centrelink. Our catchment area is the whole of New South Wales. So that blue area on the map there is where our clients can come from. The only part of New South Wales that we don't cover is down on the south coast, and the Illawarra Legal Centre has a solicitor that works with social security matters in that area. We are currently 5 solicitors and caseworkers. We do about 1,700 matters a year, both informations, referrals, one-off or extended advices, as well as representing clients to Centrelink and the Administrative Appeals Tribunal. We're also able to represent at the Federal Court, although that doesn't often happen. The sorts of things that we do really can be captured in 2 broad categories. We help people get onto a payment, or we help people to get onto the correct rate of payment. We also assist people when they've been told by Centrelink that they have a debt because they've been overpaid. One of the big barriers that people have to get help with their Centrelink issues is that they don't realise that a social security issue really is a legal issue. It's okay to seek legal help, and you can get a lawyer to help you with any decision that Centrelink makes that you either disagree with or wish had never been made. If you're referring your clients to us, we do prefer that Centrelink has made a decision already. We're not able to help people fill in application forms. The exception to that is where Centrelink has maybe not made the decision. You've been waiting for an extended period of time for a decision to be made and they haven't made the decision, they've been refusing to. Or if your client is completely off payment and is also in severe financial hardship, then we are also then able to assist. Today, what I'm going to be talking about is only legal information. It is not legal advice. If you have a client with a specific issue to do with Centrelink, please get them to seek legal advice or assist them to seek legal advice. So what I want to talk to you about today is I want to talk to you about how Centrelink define family and domestic violence, how family and domestic violence and Centrelink can intersect, what parts of the people's relationship with Centrelink can be affected by family and domestic violence. One of the most common applications that people make when they're experiencing family and domestic violence is the crisis payment, some of the common issues that people encounter, and also how to get in contact with the Centrelink social workers. So family and domestic violence is defined by Centrelink as being controlling behaviours, threats, physical violence, emotional abuse. It also includes financial exploitation. It can be both violence by a related family member, or it can be violence from someone who is not a family member but lives in the same house. That particular definition covers all aspects of social security law. So no matter what part of social security law that you're looking at, you'll be able to use this as a definition to guide what family and domestic violence is when Centrelink are looking at it. So family and domestic violence can affect your relationship with Centrelink in a number of ways. It can affect your rate of payment, and it can affect the type of payment that you might be able to receive. Often when there's family and domestic violence, it can change the care and custody of children, which will affect whether you can get one of the child-based payments like family tax benefit. your relationship may be an on again and off again and on again and off again relationship in one of these situations. And that can affect whether you receive the higher single rate of payment or that lower coupled rate. It can affect, because it can affect the rate of payment that you receive, if someone gets something wrong, if you get it wrong, or if Centrelink gets it wrong, or if you're not understanding what you're meant to be reporting, or if there's other issues going on, it can mean that you're receiving the incorrect rate and that ultimately a debt may be raised. Centrelink can also be used by perpetrators to continue that control and continue those threats and that violence. Perpetrators are often threatened to dob in to Centrelink as a means of maintaining control even after the relationship is over. They can also actually dob in either for real or made up offences. One of the other ways in which Centrelink can come into play when there's a domestic violence situation is when the perpetrator is the one that is receiving that payment from Centrelink and the victim is either not eligible for any payment whatsoever or may be eligible for those payments that are based on the care of the children, but the perpetrator is the one that is receiving it. And as a result of not having that financial support from Centrelink, they're finding it difficult or are completely unable to escape from that violent situation. So one of the first things that people often think about when they're thinking about Centrelink and domestic and family violence is the crisis payment. If your client is a victim of family and domestic violence who has left their home permanently, or where the perpetrator has been removed from their home and will not be returning, then they may be eligible for the crisis payment. It's only a single week of a primary income support payment. It's only worth 1 week's worth of payment. And the person who's applying for the crisis payment needs to be on a Centrelink payment already before they will be granted this payment. Now that means that if your client isn't on a Centrelink payment, they can make an application for a payment and on the same day make an application for crisis payment. They will process that main application, and once that's been approved, then the crisis payment application will be approved. It can also be paid more than once. It can actually be paid 4 times over a 12-month period. So that means that Centrelink are recognising that it can take multiple attempts to leave a relationship where there is family and domestic violence. Now, those 4 times over a 12-month period are 4 times for family and domestic violence. You might have a client who was eligible for a crisis payment for arriving in Australia on a humanitarian visa. They may have been eligible for a payment from being released from prison. Now, those crisis payments are completely separate from those 4 times within a 12-month period that you can get crisis payment for family and domestic violence. The one thing that you need to be aware of and keep track of is that there are really strict time limits for the crisis payment. You must put your application in time because otherwise you will not get it. Those time limits don't get extended. So, as I said, those time limits are critical and you need to make your application in time. If the perpetrator is the one that's leaving the home and your client is the one that is staying home, then you need to make, or they need to make contact with Centrelink within 7 days of the perpetrator leaving the house or being removed from the house. Alternately, if your client and the victim is the one that is leaving the property, then they need to make contact within 7 days of making the decision that they are never going to be able to return to the house. So what that means is that it might be that they left the house in the middle of an incident and they went to stay with family or friends or at a shelter, thinking that they'd stay there till everything calmed down and then they'd go back home and they'd live at home again. And they were just getting out for a brief period of time while everyone got over it and everything settled down. While they're at that alternate accommodation, they realise that this needs to be permanent, that actually they can never return, that they will never go back and live in that house again. It's from the moment that they made that decision that their 7-day limit starts. So it's from that moment, which could be days later, that they need to make contact within 7 days to Centrelink. They need to make sure they say that they're calling about the crisis payment. Because if they do that, a second time limit starts kicking in, and they will have 14 days from that telephone call, from making contact, in order to actually lodge the application. So the application process, those time limits can be quite extended as long as you get that telephone call in or that contact in within those 7 days. You can make 4 applications within 12 months, and social workers are the ones that make those assessments about whether you really are eligible. So they're going to assess whether the perpetrator really is never going to leave home. If the victim says, yes, the perpetrator's been taken by the police, they're in jail, but once they're released, they'll move back in, then they won't be eligible for crisis payment because they're not permanently leaving the house. Okay? Or alternately, if they're telling Centrelink and they've decided that, yes, they're leaving for a while, they're going to leave for a couple of weeks or a couple of months, and then they're going to go back to the house and they're living there because it's their house and they want to live there, whether the perpetrator's there or not, then the social worker is likely to say that it's not a permanent decision to leave the house and they're not eligible for the crisis payment. So social workers are the ones that make those decisions. But as I said, it's really important that when you call within those first 7 days, that you let them know that you're calling about the crisis payment. Otherwise, that second lot of time limit, the 14 days, won't kick in. So some of the common issues that people who are experiencing family and domestic violence might face that will affect their relationship with Centrelink are things like changes to the custody of children. Whether you have care of children or not, and the age of those children will affect what payments you might be eligible and the rate of payment that you receive. If there are any changes to those care arrangements, you need to be telling Centrelink within 14 days of the changes. And that includes if the perpetrator refuses to return children after a visitation and those children are taken from the victim's custody without consent. The moment that those children were not returned after visitation, the person who did previously have primary care of the children has lost their eligibility for Centrelink payments based on that care. And they need to be telling Centrelink within 14 days. If they don't, then they're at risk of getting a debt. Now, it's really important to remember and realise that if this is a situation that's facing your client, it is possible to get parenting payment for up to 8 weeks after losing care of the children if that loss of care is only temporary. Now, in non-domestic violence situations, it might be that the carer have gone to stay with a relative for time over the holidays, over the long Christmas holidays. Now, it's possible to have parenting payment paid while they're doing that. It's also possible if the loss of care was not by consent. If you're showing Centrelink that you're doing everything in your power to have those children returned through police reports, consultations with lawyers, anything else that you might be doing in order to get the children returned, then Centrelink may grant you parenting payment for up to 8 weeks while you're going through that process. But you must tell them, and you have to tell them within the 14 days. You can also get family tax benefit for a period of time as well in that situation, but once again, you need to be telling Centrelink. Now, family and domestic violence also comes in very strongly into whether you are a member of a couple or not. And whether you're a member of a couple affects your payments from Centrelink in a number of different ways. It might be that the income and assets of the partner need to be taken into account. It might be that whether you're getting that single or that coupled rate when you're getting your Centrelink payment. And when there's family and domestic violence, it's not always clear whether you are a member of a couple. It might be that you haven't told Centrelink that you are because you didn't realise. It might be that the perpetrator has forced you to lie to Centrelink and forced you to not declare that you're a member of a couple. It might be that the perpetrator is hiding their income and hiding their assets, or forcing you to not declare their income and assets, and therefore the rate of payment that you're getting from Centrelink is the incorrect rate, because Centrelink don't know all of the financial circumstances of the relationship. The perpetrator might be stealing your money, and therefore you just can't afford to survive on the money that you're getting. And so it's really important to know that these can all affect the rate of payment and the amount of money that you're getting from Centrelink and that relationship. There could be debts and all sorts that come out of these issues, and we might be able to assist with that. One of the other things that can be quite a problem with a relationship with Centrelink is when child support comes into the picture as well. So if you have children and you are no longer with the other parent, then you are required to seek child support from the other parent if you are receiving the family tax benefit. If you don't seek that child support, you will be paid at a lower rate. You'll be paid at what's called the base rate of family tax benefit, which may be significantly less than what you would be eligible for if you had sought child support. Now, it might be that you're not seeking child support because of the family and domestic violence, because you are concerned about retaliation. You are able to apply for an exemption from that requirement to seek child support. Once again, a social worker is the one that makes that assessment. The exemption is based on domestic violence and risk. There are other reasons why you may be able to get an exemption, but for our purposes today, you can get an exemption for family and domestic violence reasons if you fear violence as a result of seeking that payment. If you then in the future start getting any child support from the other party, from the other parent, then you need to be declaring that to Centrelink in order to avoid getting a debt from being paid more family tax benefit than you may have been eligible for. Another way the issues with collecting child support can affect your relationship with Centrelink is that if you are going through the child support agency, an assessment has been made for child support, then your payments from Centrelink are going to be based on and assessed against the amount of child support that has been assessed as your what you should be receiving. Now, it might be that the agency has just been completely unable to collect that money. And even though you're meant to be getting X amount of dollars per month or per fortnight, you're not. And it's just not being collected, it's not coming through, but your Centrelink payment has been reduced on the assumption that you're receiving that money regularly. That's called the Entitlement Method, and you can make an application that you be paid on what's called the Disbursement Method, which is where you're paid not on what you should be receiving each month, but you're paid on what you actually receive each month. And so it's a matter of contacting Centrelink and making a specific request that your child support be assessed on that disbursement method. If you do make that application, then you need to make sure you're telling Centrelink when you actually get the money. So if you do get any money, if Child Support Agency does manage to collect any of that money, then you need to be telling Centrelink when it comes through so that you're not at risk of a debt at the end of the financial year. One of the other reasons why you might have issues, and this one is a common one that perpetrators will often use deliberately in order to punish or inflict control or punishment onto their victims. And that's because if you're receiving the family tax benefit, then you are required and your partner is required to lodge a tax return by a particular date. And if you both haven't lodged that tax return by that date, then you will be required to repay every cent that you received in family tax benefit in that financial year. So what you'll often find is perpetrators will deliberately not lodge a tax return, knowing that by doing so, their ex or their partner will be obliged to repay a debt. Now, if the relationship has broken down, if the two people are no longer together and a debt is raised because the other party, the one that wasn't actually getting the money in their account, hasn't done a tax return, then it's possible to have that debt written off temporarily. And then when the person who refused to do their tax return ultimately does it, then that debt will be recalculated. They'll actually make an assessment on what family tax benefit you should have been paid based on the income of the two parties. And if there is a debt, then it'll be raised. And if there's not, then it's as if it never happened. Now, there are other reasons why someone might get a debt as a consequence of family and domestic violence. A victim can be lumbered with substantial debts when the perpetrator has done things. It might be that they've lied or they've hidden income and assets. They might have forced the victim to hide their income and assets. They might have forced the victim to hide the relationship and not declare that they're in a relationship. It might be that they have completely refused to provide any financial support, and as a consequence, the victim has felt that they have no choice but to lie to Centrelink. And it might be that situation we talked about earlier where the children aren't returned after visitation, and that changes the eligibility of a payment from Centrelink. Other things that can happen is that the person receiving a payment may not realise that this relationship is actually a relationship for Centrelink purposes, and Centrelink might decide it is and raise a debt for a period of time. That loss or change of care of children, even when it's not a refusal to return children after visitation, it can just be a part of that process. Or it could be when the perpetrator receives a compensation payment, which affects the income and assets of the relationship, and the other party may have a debt to Centrelink as a result, but it actually also can just mean that they've lost their eligibility for a payment full stop because of the compensation received by the perpetrator. One thing to be really, really, really clear on is that you don't have to have done anything wrong for a debt to be raised. Debts can be raised for all sorts of reasons, and there doesn't need to be fault involved. It is possible to appeal debts. We would never, ever recommend that you appeal a debt without first getting legal advice. Debts, when you appeal them, can actually go up. That $2,000 debt can turn into a $12,000 debt on appeal. If you ask Centrelink to look at whether the debt was the correct debt or whether a debt should be waived, then they may look at it and decide that actually it should be larger. So we will always recommend to get advice before appealing a debt. But just be aware that if you are appealing a debt, if you are asking Centrelink or the tribunal to waive a debt, it is possible to have that debt waived or ask for a debt to be waived due to special circumstances. There's a very wide range of different special circumstances that can be taken into account, but please be aware that family and domestic violence is one of them. And that family and domestic violence doesn't just have to be happening currently or doesn't just have to have happened during the debt period. It could be the experience of childhood, the experiences from a previous relationship. It could be that it's happening now, but wasn't happening during the debt period. So if your client has a debt and there's family and domestic violence and you're thinking about appealing it, please contact a solicitor, contact us, get some advice, and we'll be able to help you to navigate that. Now, as I've said, the social workers are involved in a lot of different aspects of people's relationship with Centrelink when there is family and domestic violence. And if you would like to contact a social worker yourself and ask for a social worker to be involved with your client, then it's a matter of calling any of the Centrelink numbers and asking for them. And if Centrelink is aware that family and domestic violence is an aspect of this person's life, then access to a social worker should be easier. but they're available to help with all sorts of different issues that your clients might have. We do other training throughout the year. So throughout the financial year, we do training nearly once a month. This is an in-depth look at different aspects of people's relationship with Centrelink, and we do a specific one on domestic violence and Centrelink. It runs for about 2 hours long, and it's a really comprehensive look at all the different things that come into play when we're talking about Centrelink and family and domestic violence. And our next one is coming up in February. If you want to head to our website and register, you can do that through Eventbrite. If you do want to send any of your clients to us, we have an advice line open on Mondays, Wednesdays and Thursdays, where we have intake officers that will take the calls and arrange for either an information or referral or for an appointment to be made with one of our solicitors. And those are the telephone numbers there that you can call. Now, if you're wanting to refer one of your clients to us, then you're welcome to send us an email or give us a call on our admin line. We do ask that clients not send us emails or call on the admin line. But if you have a client that's not able to call on our advice line, they are welcome to go onto our website, and in the Need Help section, there's a Contact Us page that they can fill in. And we usually get back to people within a few days, a week at the most. Finally, we also invite you to follow us on our social media. We update with changes in the law and changes in the way Centrelink is doing things whenever we come across them on our social media pages. We also let people know about different training and different education sessions that we have coming up. Thank you very much for today. If you have any questions or if you have any clients that you'd like to refer to us, then please give us a call or send us an email. Thank you.